Black's Law Dictionary gives us 4 definitions of bias. The first definition is called actual bias. Actual bias, very good example, came to light this week. The Washington Post wrote an article, I believe it was on Tuesday, stating that the FBI conceded that between 1980 and 2000 that hair analysis was flawed. Hair analysis was flawed, and that includes capital cases of which 14 people are now dead, either executed or died in prison. What they said was that the forensic examiners had the bias to become essentially part of the prosecution. And in review of all these cases, what they're finding is, I believe it was 95% of the cases that they've reviewed so far, and it's 200 some odd cases, the bias was in favor of the prosecution. So this is going to be very interesting to see how this all pans out. When we talk about actual bias, this is actual bias. There's also advocate's bias, type of bias number 2 defined in Black's Law Dictionary. Advocate's bias is where the attorney becomes too much of an advocate for the client. Now, here's an example. Have you ever had this situation occur? I had a case earlier this year as a document examiner. The people who retained me, the attorney who retained me, represented a restaurant who was being sued by a former employee saying, I never signed these employment documents. What I discovered when I went through and did the examination was that on 3 of the signatures, they're what we call cut and paste, meaning that they're exact replicas of each other, meaning that either 2 are a copy of a 3rd or all 3 are a copy of an unknown 4th. And I asked the attorney, do you really want me to testify in this case? Not good for your client. He said, yes, I want you to testify because the other examiner is saying that they're all cut and paste, and you're showing that they're not. Now, in cross-examination, the attorney who retained me was able to get the other examiner to say, well, using Photoshop, I stretched it this way, I stretched it that way until it fit. So he conceded that wasn't generally accepted practice and that the other ones were not really cut and paste, even though he said they were. Problem was, my question is, was he experiencing advocate's bias? Because he knew that what I was going to testify to in those 3 signatures was not really good for his client. I have no idea what the outcome was of the case. As Herbert said, we oftentimes don't learn the outcome of the case. We then have what we call implied bias, which is also known as perceived bias. Perceived bias is where we can actually perceive that there is a bias on the part of someone. So the question is, Lois,
yes.
You're an expert. The judge doesn't like the way you do your hair, or the jury doesn't like the way that you do your hair. Can that affect what their opinion is, regardless of the words you use?
Absolutely.
Absolutely. So therefore, this whole concept of perceived bias is a prejudice that is known. We saw this in aspects of trials here in the United States, all over, down south, back in the up through the 60s and so on. There's a lot of, and even today, there's a lot of implied bias going on, or perceived bias that we see. Now, in a situation I had, the case I'd like to cite, it was North San Diego County a few years ago. The implied bias between the judge and the other examiner. The other examiner went up, and I had the opportunity to sit in the courtroom when he testified because he went first. He walks up, judge says, excuse me, I have to at least let you know, when I was in private practice, I used to hire this examiner all the time. Counselor, do you have a problem with this? No, Your Honor, I don't. Why am I even here? And that, in the judge's ruling, came out that he had more of a belief of the other examiner, and the attorney would not even, who retained me, would not even go against the other examiner when I told him on break of problems in his testimony. Why? Because he probably realized, I have to appear before this judge again. I don't know this for sure. This is my hypothesis, but I don't want to offend his friend. So, interesting situation. Then we have judicial bias. Judicial bias. Case about 1.5 years ago. It was in Santa Monica, California, courthouse. I'm supposed to testify on Tuesday. Tuesday, I start to go up to testify. Other counselors, I'm sorry, Your Honor, but we have not had an opportunity to depose this expert since he's seen the original document. Now, in deposition, I was asked, have you seen the original document? I said, sorry, counselor, as far as I know, there is no original document. Here it is. After I testified the next morning and into the next afternoon about the document, I asked the attorney who retained me a couple of days later, how's it going? Because I was one of the last witnesses. He said, the judge is really favoring the other side because he said the other examiner saw the original and you didn't. Well, my report said I didn't because at the time I didn't even know it existed. Judicial bias? Had he already made up his mind on the case before I even got on the stand? Possibly.